to Lawyers Info Hub. This is your host, Mercy. Thank you for always checking up on the channel. Thank you for our returning subscribers who are always coming to check what is new on the channel. So today we're looking at the basics of contract. When you hear about contract, law of contract, what does contract mean? Now, this channel is dedicated to both young lawyers, students, people who are practicing. You might learn one or two things that will help you in your practice. So let's dive into it. And before I forget, there are tons of videos on this platform that is very beneficial to you. Just take your time, go to the channel, and consider subscribing to the channel. So let's get right into the video. So when you hear about contract, what comes to your mind? When someone is talking about contract, I have a contract with this person, or we signed a contract. What does it mean? So we're going to just look at the basics of contract. There's a lot to talk about in contract, but today we're just looking at the basics. So when you hear about contract, what should come to your mind? Now, a contract can be defined as a promise or set of promises which the law will what enforce. Promise, set of promises, is concerned mainly with relationships between persons which the law recognizes and can enforce when one of the parties or when one of the person fails to perform their own bargain. For example, I meet with someone and I said to the person, I want to buy some goods. And the person says, okay, I can supply those goods for you. And I say, okay, how much? And we just bargain prices and say, okay, I'm going to make payment for this and you're going to supply this. Yes, the person says, no problem. So there's a set of promises and obligations between the both. My own obligation is to provide the money, and the person has the obligation to provide the goods and want to buy. So in making, I'm going to just clarify it or simplify it the way that even if you're just a law student, you will understand what I'm saying. Now, what's the legal justification for the enforcement of these promises? Now, we see contract as set of promises. What is the legal justification? Why should the law hold someone liable for failing to perform what they have promised to perform? The reason is mainly it's economic, on the law of economics, yes. Should I bear the loss of having paid you money to supply something for me and you refuse to supply and you're still withholding my money? You know, most times these contracts are based on trade and what commerce as opposed to domestic arrangement. So it's beyond the realm of domestic arrangement or family issues. This person has given you money meant for something, for certain goods, and you're supposed to provide. So it's economic. One of the reasons for legal justification is that it is what economic. So it involves trade and commerce. So one should be held liable for their actions. That means if I bring out my money to buy something, I should have value for what I'm buying. Another legal justification is that so that people will know that breaking contractual promises are arbitrary. It's very important. So the second justification that why the law enforces contract is that so that people will not arbitrarily break contractual promises. So, and there are no moral justification for you to just wake up and say, I'm no more doing this, and you have failed to even reimburse the person. So it's very important also to know that there are ingredients or constituents of a valid contract. But before we go to that, we're going to look at the forms of contract, classification of contract. Contracts are divided into different ways or different forms according to the nature of the agreement that is reached by the parties. It's also according to the terms of the agreement. Now we have what we call the formal contract. What is a formal contract? A formal contract is a contract that is made by deed. It is a contract that has been in existence for a long time, and it derives its validity from the form it is made. It is known as contract under what? A seal. It must be made in writing, must be signed, sealed, and what? Delivered. A contract that is made by deed do not need to be supported by constitution to be enforceable in law. It's very important. For a law student, in understanding a formal contract, there are basic things you must know that a formal contract is a contract made by deed. Its validity stems from the form it is made. It does not need to be supported by consideration for it to be enforced by law. Now we have what we call the simple contract. What is a simple contract? All other contracts, other than formal contracts, can also be classified as simple contracts. They may be in writing, they may also be oral. Oral contracts are also called parole contracts. Parole contract. The major factor between a contract under seal or a simple contract, is the fact that a person who has furnished consideration can bring an action to enforce the contract. In a simple contract, for the fact you have furnished consideration, you can bring an action to enforce that word contract. Remember, a simple contract can be both both an oral contract or in writing. We have what we call the express contract. What is an express contract? A contract is said to be expressed when the terms of the contract are clearly stated. You enter into a contract with somebody and the person say, okay, let us identify the terms of this contract. Let us write out what this contract constitutes. Let us write out the terms, the timelines, when you're supposed to supply, when I'm supposed to pay, when I'm supposed to pick. If I pick, if the goods are not good, can I return? Those are certain terms that can be properly expressed. So in contract, tenders are received. For example, maybe for a contractor, they are being asked to submit your bid, and you submit, and from the work that is to be done, there are specifications as per what is expected from contractors. So it is expected that for you to even be paid after the job is that what you have done, does it align with those specific specifications or the outlined terms? Did you get? So an express contract, the terms are clearly stated. Then we'll have what we call the implied contract. When you hear what implied contract here, the terms are not spelled out expressly. What the court does is to construe the existence of the contract from the conduct of the parties. John says, okay, I'll give you $3,000, get me so and so. But the person did not put what is the timeline for me to receive the goods. What if I receive these goods and half of it is bad? Who bears the liability? Okay, once this goods lands in Nigeria, who bears the liability of delivery? No, those things were not envisaged. So what the court does in implied contract is that the court will construe the existence of the contract from the conduct of the parties rather than from the terms of the contract. Now, it's also important to know that we can have what we call the unilateral contract and the bilateral contract. What is a unilateral contract? A unilateral contract is a contract where one party promises to do something in return for an act by the other party, where the offeror or someone who the promisor offers a reward for an information to anyone who can find maybe a lost person. So the offeree accepts by providing the information. Okay, someone has said someone is missing in my house. If you can look, if anybody can give me useful information about this person, I'm going to give you so amount. So what happens that once those informations are provided, the person pays, or the person gives out the sum that is attached to that promise. It's a unilateral, it comes by one way contract. Now we have the bilateral contract. Bilateral contract involves the exchange of promises. The offeror promised to do something in exchange for the offeree. Who is the offeror? The offeror is the person making the promise. The offeree is the person who is to accept. So there are exchanges of, okay, if I do this, this is what I'm expecting from you in return. So that's what we call the bilateral contract. So contract can be in the form of unilateral contract, it can be in the form of what bilateral contract. It's very, very, very important. Now, some other time, you can also look at it the form that we have mentioned about a contract until which is required to be signed. We also mentioned simple contract. We've looked at unilateral contract. We've looked at bilateral contract. It's important to also note that signature. Sometimes someone might say this was not signed. There was no signature in the terms or in the agreement. A signature is not a sine qua non or an essential to the making of a valid deed, provided the deed is sealed and delivered. Now, many people have argued about there was no signature. Because there was no signature, that means I can't believe whatever promises that were considered or made by each other. Now, it's important to know that a signature is not a sine qua non, it's not is not too essential to the making of a valid contract. Once parties can say, okay, this is what I was agreed, the court will look at it. Was it signed and delivered? Each party took delivery of it. This person accepted it, this person accepted it. So the fact there was no signature, is not something that should stop the execution or something that will make one person not to be liable for that contract that both parties willfully what contracted. Now, time as the essence of contract. Sometimes there are contracts that are time bound. In a common law, the stipulation as to time in contract as a general rule, we're not really considered as essential to contract. But however, as time has gone on, with the time where we are now, time is of the essence. Somebody might need something by 2:00. Now we have the online business platform. Someone can say, okay, can I have someone who can supply small chops for me in 2 hours? And someone say, yes, I can do it. And the person did not supply till 4 hours later. Are you still expecting payment? Knowing that the contract is time bound, and maybe the people who are to use that small chops would have finished whatever they are doing. So in this time and age where time is of the essence, it is important that when contracts are made, the specifications as to time is well considered. The specification as to time. And one day somebody is selling a property, or it's okay, pay money, pay 40 million in 6 months' time, your 1-bedroom duplex or your 2-bedroom will be ready. And after that timeline, it's not ready. So when you're factoring in or when you're going into contract these days, it's important to specify with respect to time if what you are going to do or what you're doing is time bound. So the court can look at the timing in respect of contract, but it's now of essence. Where a contract is time bound, it's expected that both parties must work in line with that timing, so that we won't record issues of breach. But where there was no specifications as to timing, you can't expect the court to rule that timing was of the essence. So it must be expressly stated. It must be what expressly was stated. Expressly stated. Now, there's something we call the contract of indemnity. The contract of indemnity. In many big contracts, if you are someone who have seen a contract paper before, or even in agreements, in most agreements, there's always that indemnity clause. That indemnity clause is a clause that saves the person who, for example, is putting out money for a certain business. For example, I'm saying I want to buy a land, and someone says, okay, I'm going to buy it, I'm going to build it for you. And the person says, okay, I'm going to build it in 1 year. Pay me, instead of paying 20 million, add 25 million. That extra 5 million will make me complete that building in 1 year. I said, okay. I give the person 25 million for the person to build the property for the house for me. And after 1 year, the person has not finished building this house. I'm saying, so in the contract I'm going to sign with this person, there's supposed to be an indemnity clause. That indemnity clause is a clause that saves me by saying, if by the end of 1 year or by the end of 12 months, this person does not finish building this house, I'm no longer going to pay the 25 million, rather I'm going to pay 20 million. So indemnity clause is like a lifesaver clause in every contract. That is why we are advised that once you're going into a contract, an agreement, carry a lawyer along. Indemnity clause is purposely, inserted in a contract to save, both parties too, to save both parties. And it's important that you that is signing a contract reads the contract very well. If you don't understand certain legal terms, revert to your lawyer to help you go through this contract. Any contract you want to sign, let it be well read and understood by you. So a right of indemnity in an incident of certain legal relationship, such as, for example, agency or master-servant relationship, it arises where the indemnifier promises to meet any legal liability which the indemnified is held to be under. Just like I explained to you, that indemnity clause in my contract, in the contract I just gave you an example, is that if this person fails to develop this property or build this property within 12 months, I will no longer pay the 25 million I agreed, I will pay 20 million because he didn't meet up to the timeline. So that indemnity clause is usually inserted in the contract so that both parties will know that there is risk and you're going to lose if you do not, ensure that this contract meets the timeline. So indemnity clause is very important. The contract of indemnity. How will I be indemnified? How will I be able to, how will I be able to assuage my losses if timelines are not met? So indemnity is very important. So most contracts always have that indemnity clause of, if this person fails to do this, this is the consequence. And the person has said that I'm going to take this, these consequences will fall on me if I fail to do this. So it's very important in every contract. You're signing, you're part of a contract, always look out for the indemnity clause. Indemnity clause. So this is just the basis of what a contract looks like. I'm going to do another video on elements of a contract. What should a contract contain? What we just looked at is we define a contract, we looked at the various forms of contract, we looked at the issue of signature, we looked at the issue of indemnity. This is just the basics. So I'm going to do another video where I'm going to explain in details what a contract should contain. What are you going to see in a contract to say, oh, wow, this is a valid contract? I have several videos in hundreds on this platform. Just take your time. Don't be in a hurry. Take your time, go through the channel. You'll be amazed at the level of wisdom, at the level of work we have putting out videos that will help you. Are you a law student? This channel is for you. Are you a young lawyer? This channel is for you. Even as an old lawyer, this channel is amazing and is out for you to become better in your practice, to become better in your studies. It's just out there to help, to push out legal education in the most simplified way. Many people are scared of law because they feel law is too rigid. There's a lot of ambiguity in law, but we're trying to break it down in a most simplified way for you to understand and be able to, assimilate with ease. With ease. So if you're yet to subscribe to the channel, please consider subscribing. For those who are watching and those who will watch later, I really appreciate you. Share this video to somebody who will benefit from it. Don't be stingy with this video. Share it with your friends, share with your colleagues, share with your students, share it amongst your friends. Because I know that few things you might learn here might be very useful for you in your studies, in your practice. I'll see you in my next video, and check out the other videos. Amazing videos, amazing. This platform is for you. This platform is for every law student out there. This platform is for every young lawyer out there. We want you to become better. We want to enrich your knowledge. We just believe that if you're simplifying law concepts, it will be easy for clarity, assimilation, and understanding. Yes, just take care. I remain your host, Mercy. Take care. Bye.